Senate Bill 290, Senator Fenberg, Representative Amabile, concerning natural medicine and in connection therewith making an appropriation.
Senator Fenberg.
Thank you, Mr. President. I move Senate Bill 290 on third reading and final passage.
Is there any discussion? Senator Gardner.
Thank you, Mr. President. We had a good discussion, a lively discussion on natural medicine legalization and regulation yesterday. Nevertheless, it's a 87-page bill. I'm astounded that someone hasn't asked that it be read at length on second reading or third. But when things are read quickly at 200 words a minute, you miss some of the details. I think that our founders, framers of our Constitution that provided for reading at length on second and third reading were very well intentioned, but it would be even better in my mind that they say the bill should be explained in detail by the sponsor on second and third reading. So this bill is occasioned and required by the passage of Proposition 122. And a lot of the discussion yesterday was about how this bill implemented 122 and what the concerns were about that. So when you look at the bill, it does a lot of things that the proposition did not do. I mean, it provides a set of definitions and a regulatory framework. You know, the bill talked about natural medicine without, or the proposition did, and the bill picks up that title. I recall that when Leg Council met about this, there was dispute about whether psilocybin is a natural medicine, but you know, you've heard me say you can call an apple an orange and an orange an apple and a horse a cow. We're going to call natural medicine psilocybin or psilocin. Those are the substances in mushrooms that have the hallucinogenic effects. And then there's a whole set of things on page 7 and 8 that I'm not going to try to pronounce for you, although mescaline is something that is included if it's recommended by the board. Now the board, you got to go back to the definitions. Who's the board? The board is the State Natural Medicine Advisory Board created in section 12-170-106. Well, 12-170-106 is over on page, got to go here, 18. So there's going to be a Natural Medicine Advisory Board that has 15 members. That'll be very efficient. To advise the division being the Division of Professions and Occupations, created pursuant to section 12-2103. That's a DORA thing. to advise the division and the state licensing authority. The state licensing authority is going to be look at that definition. It's the authority created for the purpose of regulating and controlling the licensing of the cultivation, manufacturing, testing, storing, distribution, transportation, transfer, and dispensation of regulated natural medicine and regulated natural medicine product in this state pursuant to Section 4450-201. You know, it gets pretty complicated because you go here to 4450. 4450 is kind of created out of whole cloth in this bill. I'm talking about the board, and the next thing you know, I'm talking about the state licensing authority. The governor's going to appoint initial board members on or before January 31, 2023. So with the consent of the Senate, so members, that'll be probably the Health Committee. That'll be one more set of confirmations that'll come to us. 7 members with significant expertise and experience in one or more of the following areas. Natural medicine therapy, well, that'll be an advocate for natural medicine therapy, medicine and research. That will be an advocate for mushrooms. Mycology and natural medicine cultivation, well, will be an advocate for mushrooms. Licensee qualifications, that might or might not be somebody there. Emergency medical services and services provided by first responders. That may be somebody who's actually seen the deleterious effects of these substances. Mental and behavioral health care. Well, that could well be someone who understands the dangers. Healthcare insurance and healthcare policy. So there'll be someone from healthcare insurance industry or healthcare policy. And the next thing you know, we'll be dealing with whether or not these substances ought to be covered by your health insurance. There'll be a bill sooner or later to mandate that when this is prescribed by a natural health provider, that it ought to be paid for by your policy and mine. And public health, drug policy, and harm reduction. And 8 members, so that'll be a majority, with significant expertise and experience in one or more of the following areas. Religious use of natural medicines, issues confronting veterans, traditional indigenous use of natural medicines, levels and disparities in access to healthcare services among different communities, and past criminal justice reform efforts in Colorado. At least one of the 8 members must have expertise or experience in traditional indigenous use of natural medicine. Then the board includes the executive director of the Department of Revenue, or if he's too busy, the executive director's designee, I'm thinking that's what's going to happen, serving as a non-voting member. We want to make sure that we stagger this board. 7 of the members are appointed to a term of 2 years, and 8 members appointed to a term of 4 years, as designated in the governor's appointment. And it goes on and on. But we probably need to talk about the state licensing authority, because the board is going to make recommendations to the director and the state licensing authority related to, but not limited to, accurate public health approaches, research related to the efficacy and regulation of natural medicine, proper content of training programs, tiered facilitator licensing, and on it goes. So who's the state licensing authority? For the purpose of regulating and licensing the cultivation, manufacturing, testing, storage, distribution, transport, transfer, and dispensation of natural medicine or natural medicine product by and between, not just by, but by and between natural medicine licensees in the state. There's created this state licensing authority, which is the executive director or the director of the natural medicine division if designated by the executive director.
Senator Gardner, would you like to go into your next 10 minutes?
Yes, please, Mr. Chair. Time flies.
Please.
The executive director is the chief administrator officer of the state licensing authority. And this authority has some powers and duties. I'll spare you the rest of the paragraphs because they become somewhat tedious. Reading this, it turns out that reading this either in your bed or in your easy chair in the evening has resulted in people nodding off. The state licensing authority shall, beginning on or before December 31, 2024. So the way that works is they can begin pretty quickly once they're begun, but they have to begin by the end of 2024 so that on the 1st of January 2025, they are up and operating. Grant or refuse state licenses for the cultivation, manufacturing, testing, storage, distribution, transport, transfer, and dispensation of regulated natural medicine or regulated natural medicine product. Suspend, fine, restrict, or revoke such licenses, whether active, expired, or surrendered, upon a violation of this Article 50 or a rule promulgated pursuant to this Article 50. And impose any penalty authorized by this Article 50 or rule promulgated pursuant to this Article 50. The state licensing authority may take any action with respect to a registration or permit pursuant to this Article 50, as it may with respect to a license issued pursuant to this Article 50, in accordance with the procedures established pursuant to this Article 50. So it's all about Article 50, which this bill is creating, adopting. As a member of the Committee on Legal Services that reviews each and every new rule promulgated in Colorado, I can see that we're going to have some rule review cases out of this just because of the sweeping authority. Maybe not, but I think it's somewhat likely. It says promulgate rules for the proper regulation and control of the cultivation manufacture. Who decides what's proper? I guess the authority decides what's proper. Conduct investigations and hearings, gather evidence, and pursue disciplinary actions with respect to licenses when the state licensing authority has reasonable cause to believe that a person or entity is violating what? This Article 50, or a rule promulgated pursuant to this Article 50. This is an interesting thing. Not only can they conduct investigations, they can petition the district court for an investigative subpoena applicable to a person who's not licensed pursuant to this Article 50 to obtain documents or information necessary to enforce a provision of this article or a rule promulgated after reasonable efforts have been made to obtain requested document. Now, I don't know what reasonable efforts are. I mean, I can argue once the licensing authority does it that they're not reasonable, and they would have to demonstrate that they are, but we don't really have any parameters other than you have to be reasonable. You know, I, for my own part, am always reasonable. and sometimes you are not reasonable. And many times people tell me that I'm being unreasonable, and I don't think so. So when we legislate something to be reasonable, we open the door for lots of discussion. They're going to do things like develop forms and licenses and ID cards and applications. They just have all sorts of powers. What about the rules? The rules must include the following subjects. So I think when the Office of Legislative Legal Services does a rule review, they're going to look at that and say, okay, well, we got to see whether the rules include things, because if not, then they're not appropriate. Procedures and requirements consistent with this Article 50 for the issuance, denial, review, reinstatement. Oversight requirements for licensees. As I read all of this, I realize that those attorneys who are involved in the cannabis regulation business probably will be expanding their practices to deal with the natural medicine regulation business. And there will be a whole set of other practitioners who deal only with natural medicine. So there will be simple 17th Street lawyers making scads of fees off of just simply reading Article 50, which is a challenge in itself. There's going to be a natural medicine independent testing and certification program for licenses within an implementation time frame established by the division, requiring licenses to test regulated natural medicine and regulated natural medicine product to ensure. So we're going to license the product and we're going to license the lab. And talk about a cottage industry. Now, this is all necessary. I don't point all these things out to necessarily be critical of them. It is incumbent upon us to create a regulatory structure once the people of Colorado legalized what they refer to as natural medicine. But it does demonstrate that when you do this sort of thing, the bill and the law runs to 87 pages pretty quickly with all the things. There's not only required rulemaking, I think is the term here, mandatory rulemaking, mandatory. Then there's permissive rulemaking. This will be interesting because the Office of Legislative Legal Services will look at this and say, okay, these are things that the licensing authority can promulgate rules about. They don't have to. And here's a, I think, really troubling phrase for rulemaking. It says, rules promulgated pursuant to section 4450-202-1B may include, but need not be limited to. Now, does that mean that this bill, this statute is going to give the licensing authority just authority, blanket authority to regulate about natural medicine? I don't know, let me look here. Pursuant to 4450-2021B. Promulgate rules for the proper regulation and control of the cultivation, manufacturing, testing, storage, distribution, transport, dispensation of regulated natural medicine.
Senator
Regulated
Gardner.
nat-
I hate to inform you your time has expired.
Thank you, Mr. President. I regret that very much. Time flies when you're trying to discuss a bill for the people of Colorado and intelligent vote on it, but I thank you very much for your courtesy.
Senator Van Winkle.
Thank you, Mr. President, and I want to thank the President for the hard work of bringing this bill. I think what's getting lost here, and often gets lost in committee, which the committee does its job, which is a committee gets down into the weeds, it gets down into the nuts and bolts, gets down into the commas, the periods, the sentences, the semicolons, and the cross-references, things like that. The committee got very in-depth into this bill, into the natural medicines that are being essentially regulated by this bill. But I think what is being forgotten by this body and what largely got lost in committee is the overall picture here, which is Prop 122. The voters of Colorado enacted the legalization of these products through Prop 122 in November of last year. And what that did is it completely decriminalized the personal possession, the growing, the sharing, and the use of these quote-unquote natural medicines. So right now in the state of Colorado, 5 of these natural medicines have been fully decriminalized for persons 21 years or older for personal use, which is defined as, and this is again fully legal today in Colorado, possessing, storing, using, processing, transporting, purchasing, obtaining, and ingesting natural medicine for purchasing, for personal use, or giving away natural medicine for personal use. Now that is all completely legal in Colorado today. So on the very big picture scale of what's happening here is the bill by the president here, Senate Bill 290, is trying to put some guardrails on that. So it's just not the complete Wild West of the first state to have natural medicine legalized with no rules whatsoever. It's a little bit like if we got rid of all regulations dealing with marijuana, it really wouldn't, that would be a bit crazy because marijuana would still be legal in Colorado, there just would be absolutely no regulations. So what we have here is a legalized product that is considered natural medicine, totally legal in the state of Colorado. And what this bill does is it tries to regulate it and keep it somewhat confined to certain rules and ideas and principles. Now it grants appropriate rulemaking authority to the Department of Revenue. That makes sense because Department of Revenue does have some experience dealing with something similar, which is through the Marijuana Enforcement Division. It's very different, and I hate comparing marijuana to these natural medicines, but of course, Department of Revenue is a logical place for that because they will oversee the licensing of the healing centers, which also involves the cultivation, transport, and things like that. To compare it to marijuana in somewhat, Department of Revenue, Marijuana Enforcement Division oversees the transportation of marijuana throughout the state of Colorado. It oversees the selling of it, the selling of the products, making sure that there's high compliance in terms of checking IDs, things of that nature, and making sure everything is labeled properly, all of that stuff. So Department of Revenue has great oversight over that. Then Department of Regulatory Affairs, what they're gonna be doing is licensing the facilitators, and that makes a lot of sense too, because that's, of course, Department of Regulatory Affairs. They oversee everything from, I mentioned the licensing of architects earlier today. Bring that back up here. It'll be the licensing of facilitators, and it'll be a legal profession in the state of Colorado. Again, I just want to take the body back kind of to the bigger picture, which is these things were legalized by the voters in November of last year. And what this bill is trying to do is put some guardrails around that so it's not just a complete Wild West with no rules, no regulations, and no oversight whatsoever. So I thank the President for bringing the bill, and I'll be a yes vote.
Seeing no further discussion, the motion is the passage of Senate Bill 290. Are there any no votes? Mr. Minority Leader, Senators Gardner, Rich, Baisley, Will, Simpson, Pelton R, Pelton B, Liston, Smallwood. With a vote of 25 ayes, 10 noes, 0 absent, and 0 excused, Senate Bill 290 is passed.